Hello. Today we're going to talk about, should you negotiate a personal injury claim or file a lawsuit? Imagine you were injured in a car accident caused by someone else. You have hospital and doctor bills, costs of medications, bandages, and continuing therapy bills. You're hurt, you can't work, the pain you suffer continues daily. What do? Should you file a lawsuit against the at-fault driver? Or do you file a claim and try to negotiate a settlement? A personal injury claim and a personal injury lawsuit are separate and distinct from one another. It's important to understand which one best applies to your situation. We're going to use the example of a car accident, but the information here can apply to all types of personal injury cases, including slip and falls, dog bites, defective products, etc. So let's talk about the difference between a claim and a lawsuit. A personal injury claim is between you and the at-fault driver's insurance company, before any lawsuit is considered. The claims process is a series of negotiations between you and the insurance company's claims adjuster. The negotiations hopefully result in a compromise settlement payment where both parties are satisfied. Now let's touch on a personal injury lawsuit. A personal injury lawsuit is filed when the negotiation process breaks down and a compromise can't be reached. The breakdown may occur because the claims adjuster denies their insured was at fault or doesn't agree with the severity of your injuries and the amount you're demanding. When claim negotiations hit a wall, the next step is a lawsuit. So, it makes sense to begin with a personal injury claim. A claim begins after a victim is injured or suffers property damage or both, caused by another driver's negligence. To cover the resulting costs, the victim pursues the at-fault driver, who turns the matter over to his insurance company. Once the insurance company is notified, it generates a claim number and assigns the case to a claims adjuster. Then the adjuster opens a claim and contacts the victim to negotiate a settlement. If the two can agree on a settlement, a lawsuit will not have to be filed. To settle the case, the claims adjuster needs proof that the accident was caused by her insured, the at-fault driver, that her insured was negligent, and that the victim's injuries are severe enough to qualify for a settlement. To get this proof, the adjuster will investigate the facts of the case. In your case, this investigation may include reviewing your medical charts and bills, speaking with you and any witness to the accident, reviewing the police report, going to the scene of the accident and taking photos, looking over the damage to your car and estimating repair costs, evaluating any other evidence you provide. Now, your conversations with the claims adjuster need to be accurate and support your case. During the claims process, you must convince the adjuster of the following. 1. Their insured's negligence caused the accident. 2. Your injuries are real and required medical attention. 3. The cost of your medical treatment is substantial. 4. Your out-of-pocket costs are real, medications, crutches, transportation, etc., and directly related to the accident. 5. Because of your injuries, you were unable to work and earn an income. 6. You suffer continuing pain and discomfort. Now, when her investigation is over, the claims adjuster will make a decision based on the information she collected. The decision can range from paying the entire amount of your demand to paying nothing. Generally, the adjuster's response is somewhere in between. At that point, you and the adjuster start negotiating. If you eventually come to an agreement, the insurance company sends you a release form and a check. Once you sign the release and cash the check, your claim is finished and final. You won't file a lawsuit or involve the courts in any way. So let's explore what happens if you weren't able to come to terms. Beginning a personal injury lawsuit. A lawsuit begins when you can't reach an agreement with the claims adjuster. Technically, you can file a lawsuit at any time, starting the day of the accident, but for most minor incidents, a lawsuit is the last resort. It's only considered when negotiations break down and other methods of resolution have failed, like arbitration, mediation. A negotiated settlement is often the best result because it avoids the high costs and lengthy duration of a trial. Although you might not be satisfied with the amount of money being offered, before you refuse, consider the expense and time needed to pursue a lawsuit. If you're not familiar with the costs of a lawsuit, now's a good time to think about it. It can include filing fees for the petition, the cost to have a sheriff or constable serve your lawsuit, time off from work, court reporter costs for depositions and transcripts, expert medical testimony from doctors at depositions and trial, copying costs for medical reports, police reports, witness statements, etc. This is difficult for people because it gets emotional. But listen, never file a lawsuit because you're angry or indignant over the amount the insurance company offers to settle your claim. filing a lawsuit should be an objective decision. If the injuries you suffered are not severe enough, you may be wasting your time and money at the courthouse. So what injuries are serious enough to merit a trial? Threshold injuries are very serious injuries. To fall in this category, the injury must have caused significant damage and either be permanent or limit a person's ability to do normal daily activities for a specific period of time. Many states use what's referred to as a threshold injury doctrine. If you're injured in a car accident and fail to meet the threshold, your case could be dismissed. Although the various states define threshold injuries differently, some are common to all, and those threshold injuries include death, dismemberment, significant disfigurement or scarring, fractures, loss or significant limitation of body organ, a medically certified injury or impairment that may be non-permanent, which prevents you from performing acts that are customary and usual for at least 90 days of the 180 days following your injury. Make the decision to file a lawsuit carefully. You don't want to file a suit, then have it summarily dismissed. If your injuries don't meet the threshold, and you live in one of the states adhering to the doctrine, give very serious thought to settle your case, even for less than you think it's worth. Regardless, it's always a good idea to speak with an attorney. It's a good time to talk about arbitration. You've probably heard the term before. Arbitration can take place after settlement negotiations fail, but before filing a lawsuit. It's like going to court without actually having to go to court. In arbitration, both sides agree on a third party called an arbiter or arbitrator who listens to both sides and decides the outcome. In most cases, once the arbiter makes a decision, it cannot be appealed. Arbitration is an excellent alternative to filing a lawsuit. There are various types, including one that guarantees you'll receive at least some amount of money. Compared to a lawsuit, arbitration takes less time because the hearing can be set quickly. The costs are also much lower. Now, how long do you have to take action on a personal injury claim? There's a statute of limitations. Statute of limitations means there's a time limit for filing a lawsuit. If you fail to file your lawsuit before time expires, you'll lose the right to sue and may be left with nothing. Now, each state has its own statute of limitations for personal injury cases. Most are between 2 and 3 years. So, check your individual state laws. Normally, the state where the accident occurred is the state whose statute applies. With few exceptions, it's also the state where the lawsuit must be filed. That wraps up our talk on whether you should negotiate a personal injury claim or if you should file a lawsuit. To learn more and get a free case review, visit injuryclaimcoach.com. We thank you for watching and best of luck with your case.